So President Trump is back in the office now for a week and a half at the time of this recording. There have been multiple different executive orders in immigration that's going to affect. I just want to let everybody know that many of these are meant to scare, to intimidate, and you've got to remember that he wants to try to discourage illegal entries at the border, to take care of the crisis at the border. So a lot of these are designed to spread fear. Nonetheless, it is going to affect, and there's going to be increased enforcement. So it's good to know them. I'm going to talk about 4 of these. I'm going to talk about the Laken Riley Act. I'm going to talk about the Denaturalization Executive Order. I'm going to talk about the extension of expedited removals and what that means, and then also some recent changes to the adjustment of status process and some potential future ones that may happen. Let's go ahead and get started. But before then, please subscribe to my channel, like, share with your friends, and appreciate your support. President Trump just signed into law the Laken Riley Act, and this is his very first law that he signed as president. Many are thinking, wait a second, what has been going on this whole week? He's been passing laws. No, those are executive orders. Those are policy changes. Obviously, they do affect the way they enforce the laws, but this is an actual law that went through both houses of Congress. Remember, he has control. The Republicans have control of the houses, but there was some bipartisan from both parties support for this particular law, which affects detaining immigrants who have certain criminal offenses. And so before we get into it, I want to discuss a little bit about mandatory detentions. They're already part of the law, the Immigration National Act. We call them mandatory detention, where certain individuals who were apprehended, arrested, convicted for violent offenses, what we call aggravated felonies in the immigration world, or 2 or more crimes involving moral turpitude. Also, what could affect it is arms offenses, gang-related offenses, drug offenses. These type of things were considered mandatory detentions, which ICE wouldn't give a bond to the person, release them. And then also under the Immigration Nationality Act, it removed jurisdiction from immigration courts, judges, to be able to grant a bond. So a person would be stuck, detained, and they'd have to fight out their case while they're being detained. Now, this is different than what we already had in the books. This actually, a couple of things that are distinct from this is it adds additional crimes. And these crimes are they're not as serious as the ones that we were used to. And what you see right here, theft. Those who have been accused of theft, arrested or convicted, theft, burglary, assaulting a law officer, or a crime of cause death or serious bodily injury. This is what is listed on the announcement today from DHS, but I want to jump to the actual bill because it's a little bit different there. So I'm going to jump over here. So here's the actual bill, and you'll see, let me highlight that for you. So those who have been charged with, arrested for, convicted of, or have admitted to committing acts that constitute the elements of a burglary, theft, larceny, or shoplifting. This is very concerning because, somebody who gets arrested for a shoplifting, stealing something in the store or the mall, that can get you arrested, turned over to ICE, and then you would be considered mandatory detention, to where they would not release you and you wouldn't be eligible for a bond. Now, one thing here is you'll see that this is directed to the Department of Homeland Security. So that's the enforcement of immigration laws. That's going to be your ICE, that's going to be your Customs Border Patrol, and probably USCIS to some extent, but mainly ICE and Customs and Border Patrol and other federal agencies that are going to start enforcing immigration laws. But you'll see that this is not extended to the EOIR, the Executive Office of Immigration Review. That's the immigration judges. So, it appears that you would be able to, if ICE won't release you and grant you a bond, you may be able to request, and it looks like you request a bond from an immigration judge if it's not one of those ones that are in the Immigration and Nationality Act that I mentioned beforehand that removes the judge's jurisdiction. If there's any questions about this, there are certain hearings. It's called a Joseph hearing, to where you can try to show that the hold ICE to their burden to prove that these elements would consist of a mandatory detention in the Immigration and Nationality Act. It'll be interesting to see how this will play. And we've also recently learned that the Trump administration intends to ramp up their denaturalization process against certain individuals. This is something that he attempted to do in his first 4 years. It wasn't very successful. There wasn't a lot of people who were denaturalized. It was usually used for those who concealed that they were members of a Nazi party or a criminal organization, terrorist organization. It wasn't revealed in their process, and they became citizens. And then the Immigration National Act does allow the government to go back in to strip individuals of their citizenship. This is a very extreme measure. A lot of people are really scared about this who have naturalized, become U.S. citizens. I've gotten so many emails, calls about this of any of the other ones from prior clients. And really, you should not be scared if you have nothing to hide. If you had anything that happened, a criminal conviction or certain thing prior to becoming a citizen, and you disclosed all that, you should not worry. Although they might start extending this towards those who got their citizenship unlawfully because they did not disclose a material fact. So the way that the government can do this is either through a civil proceeding or a criminal. And there's some differences between them, but the main ones, if it's civil, there's not necessarily a right to legal representation or jury. And the standard of evidence is clear and convincing and unequivocal evidence. Whereas for the criminal, if there's a criminal proceeding, it is beyond a reasonable doubt, and there is a right to a jury. So it's a lot higher standard. Like I said, this is a very extreme measure, very costly, very difficult to do. I don't see that it's going to be used widespread. It didn't during his first 4 years. Most of his intentions and orders are meant to scare. They're meant to frighten people into becoming U.S. citizens, but mainly to frighten all immigrants, mainly those who are trying to enter the country illegally, and then also those who commit crimes. So if you have a question, on this, you definitely would want to go seek legal advice. President Trump is also wanting to expand expedited removals beyond the border. And for those who don't know what an expedited removal is, starting under the IRA Act of 1997, that allowed immigration officers the authority to expeditedly remove without a hearing certain immigrants entering at the border. And we've seen a lot of those. These typically are for those who enter the country illegally, but also are using fake documents, a false claim to U.S. citizenship, or other criminal activity. President Trump intends to extend this beyond 100 miles of the border for those who are inside, and there is legal authority to do so under the Immigration and Nationality Act, but he's extending it pretty far from. This law would allow ICE to detain and expeditedly remove generally those who are either found having made a fraud or misrepresentation, a false claim to U.S. citizenship, or are inside the country without proof of a legal entry and cannot prove that they have been living inside the United States for more than 2 years. So this is something that those who are concerned If you've been here for more than 2 years, gather documents, get documents together ready, keep them in a packet, a physical packet, keep them electronically in a USB in the cloud, and have those ready in case you're picked up so you can be able to show that you're here 2 years. But most importantly, remember, you have the right to remain silent if you are encountered from a law enforcement officer who is asking about your legal status, where you're from. You do not have to answer them those questions. You can give them their name. You have to give them your name. You be respectful to them, but you have the right to remain silent, and you have the right to talk to an attorney. That legal advice, a consultation with an attorney to put in practice a plan that you can have ready in case you are encountered and ICE officers are trying to expedite a removal against you. Last, I want to mention a recent change last week to the process for adjustment of status. For those who had issues with the COVID-19 vaccination, are unable to get it for whatever reason, it is now no longer required as of January 22nd of this year. So that's good news. That will not affect your application for adjustment of status. However, we are expecting some changes, most likely similar to the ones that were implemented during Trump's first 4 years, or that he tried to do, that can affect adjustment of status processing, getting your green card here in the United States. One of those is we've seen the last several years a waiver of interviews. And that has helped speed up the process. That means marriage-based cases, parents petitioning children, children petitioning parents, employment-based cases too, where they waived the interview, where you didn't have to come in from an officer, and that has been really nice and speed up the process. We expect that the Trump administration most likely is going to start interviewing again. They did so during his first 4 years. Also, he tried to implement a more strict public charge requirement where it minimized the weight of an affidavit of support that was only was going to be taken as a factor in the case, and they issued a new form. It was like a 20-page form where you had to list out many different factors: your credit scores, debt, your household income, and so many other things to take into consideration to see if that person would be considered a public charge. And that was just another obstacle, invisible wall, so to speak, in the process of the adjustment of status. So that could come back too under the Trump administration as well. So stay tuned. Again, thank you for watching and supporting me. If you haven't already, please subscribe. Click that subscribe button below. Share it to other people who might need this information. I am Attorney Pace Rawlins, el abogado a tu alcance.